Hey everybody, welcome to the Home Care Forum podcast with your hosts, Sasha Guillaume and Emina Poricanin. We have a special guest on today, and I'm going to throw it to Emina because Emina has worked with our guest and can introduce him. Emina.
Worked. We've done more than work. We've spent hours and years of our life in the trenches together. So it's my really honor to introduce John Godwin, my former partner at Hodgson Russ, and he's still a partner in the Labor and Employment Group at Hodgson Russ. At this point, John, are you running the show over there in this department?
Yeah, some days it feels like it. Yeah,
Well, thanks so much for taking the time to do this.
of
Uh,
course.
John is an expert in various areas of the labor and employment law, federal and New York State. But the topic of today's conversation is the WARN Act, federal and state WARN Act, as they may apply in different situations. So I'll turn it over to him to just kind of tell us a little bit about this law, because usually when I mention the WARN Act, people say the War Act, is that like when the president gets to exercise executive powers to shut the business? Like I hear all sorts of questions. I receive quizzical looks. So initially, John, tell us what this is about.
Yeah, yeah. Well, thank you both for Sasha and Amina for having me on the podcast. It's a pleasure to be here and talk with you guys about the WARN Act, not to be confused. I mean, as you said, with the War Powers Act, right? So the WARN Act, we've got really in New York at least, we've got two laws we're talking about here. We're talking about the federal WARN Act, which has been around since 1988, was actually signed into law by Ronald Reagan. And then we've got the New York State WARN Act, which has been around for the better part of a decade or so. And they both are really directed at the same thing. Conceptually, they're both laws that are designed to warn, hence the name, give advanced notice, if you will, to employees of any plant shutdown, any facility closure, or significant layoffs. That's really what it's directed at, is significant loss of employment. And each law kind of has its own notice requirements. The federal law requires 60 days of advance notice of any employment losses in connection with a facility closure or a significant layoff. New York, of course, being New York, right, has to go above and beyond. So New York requires 90 days of advance notice of a plant closing, a significant layoff, or a relocation of work from a facility at a location that's more than 50 miles from where it's being performed today. So you've got New York kind of stretching the amount of notice that's required. 90 days advance notice of these types of things is a real heavy obligation on employers. That's projecting 3 months out. It's difficult to see a few weeks or a month or two into the future in business. 3 months is often very challenging. And then what New York also did when they rolled out their WARN Act is they lowered the thresholds of what counts, what triggers this notice obligation. They lowered it under the federal law. Typically, there's a couple of different thresholds, guys, but what you're really looking for to be in the game, if you will, under federal WARN Act is at least 50 full-time employees that will be losing their job. New York cut that in half. So all you need in New York to potentially be in the game is 25 full-time employees who are going to sustain an employment loss. And if you've got that, then you've got this 90-day notice obligation. So, the New York WARN Act law, when it came around, was a significantly broader series of protections for employees, a significantly longer period of advance notice that employers were required to provide. And it captured, with those lower thresholds, a lot more activity, a lot more employment loss activity, layoffs, facility closures that were too small historically to trigger federal WARN Act notice obligations. So it's been it's been a real game changer in New York. New York's not the only state with its own WARN Act. There are over a dozen states that have their own what we call mini WARN acts, little state WARN acts, that can be a real issue, a real challenge for businesses to deal with. New Jersey is one that comes to mind that has had its own WARN Act for many, many years, but just recently, in fact, in the midst of the pandemic, changed their WARN Act to be substantially more onerous than most states' laws. California also comes to mind as well.
So a number of questions come to mind, and in no particular order. There has to be an employment relationship, right, initially for the notice obligations to be triggered. So for employment relationships, and there are all sorts these days, right? We are in the gig economy. Arguably, some companies could seek to avoid these obligations by arguing that the individuals who are supposedly losing employment are not even employees.
Right. Yeah. Yeah. And that's a really good point, Amina. That's something that we have to focus on quite carefully when we're advising our clients around these WARN Act issues is the folks that work for you, right? The people that turn the wrench, if you will, for the business, but that who are not considered by the employer to be W-2 employees, right? So exactly what you just said, Amina, 1099 contractors is going to be a category there, but not the only category, right? You might have temporary employees that are, technically on the payroll of someone else. You may have leased employees or PEO employees. And, understanding how those folks potentially could count, right, is important because, if they are in fact a bona fide independent contractor, they're not counted. They're not issued notice. You don't owe them liability if you fail to issue notice. But that's the $64,000 question, right? Are they properly classified as independent contractors? And, when you're planning for a WARN Act event, understanding, where those pools of labor, the non-traditional contingent, however you want to think of them, pools of labor are and what the plan is for them, that's really important so that you don't have a blind spot to something that could result in liability down the line.
All right, thanks for all that, John. But could you please elaborate more on the notices and what kind of information that we need to provide as employers to our employees that may be affected here?
Yeah, Sasha, that's a really good question. And in New York, it's one that's seen a lot of change here in just the last couple of years, and changes that are frankly very challenging for businesses to deal with. Historically, under the Federal WARN Act, the notice could be quite short, like a paragraph and not much more. New York, when it passed its mini WARN Act, whatever it was, 10 or 15 years ago, really added to the information that is required to be included in those notices. And the notice got significantly longer. Well, now, just within the last year or so, New York has gone back to the well, to both regulatory and statutorily, and added to the notice obligation burden of an employer, right? And they've added to it in two different ways. There are now new recipients that are required to get notice. One, and two, there's additional information that needs to be included in the notices. So why don't I take both of those in turn? Previously, you had to issue notice to, of course, the affected employees. That's kind of straightforward. I think everyone kind of intuitively understands that. But beyond that, you needed to issue notice to the Commissioner of Labor, to the local Workforce Investment Board, which is kind of structured on a county by county basis here in New York, to that local Workforce Investment Board that had jurisdiction over the site that was closing or having the mass layoff, and then to any union that represented the affected employees. If there is no union, then it's just NA, as well as potentially the chief elected officials of the municipality that the employer paid the largest amount of taxes to. That was kind of the universe of notice recipients. Now, Governor Hochul signed an amendment to the law that adds to that all municipalities where the site is located, school districts, You got to send the notice to the school districts as well. So there's these additional notice obligations. And then the local workforce investment board is also a bit broader too. In addition to that, now New York is requiring significant more information be shared with the Commissioner of Labor notice. Specifically, you have to upload a spreadsheet in a portal about all the impacted employees. And this impacted employee spreadsheet has to have very detailed information for each employee. So if you're doing a RIF of any size, right, you're typically doing it under significant time pressure, right? That, hey, we've just kind of made the determination we need to close this facility or we need to lay off a significant segment of our workforce like tomorrow. And pulling this type of information together with that level of detail and specificity and that time frame can be very, very challenging. To give you a kind of a hint or a flavor, if you will, of what the commissioner is looking for, she's looking for the hours that these folks work during very specific 90-day periods. She's looking to know, their home address, their email, their personal email addresses, their personal cell phone numbers, right? She's looking to know how they're paid. Are they paid hourly? Are they paid salary? Are they paid a commission? All of that information, for hundreds, perhaps thousands of employees has to be put into a spreadsheet, uploaded to the portal with the notice. And that all has to be done 90 days in advance. So it's really made the process of preparing the WARN notice from, what used to take maybe between me and a client a handful of hours, it's now turned into a day and a half type of ordeal to pull together all of that data. And, I can't help but think, guys, that a reason for this is to create more procedural hurdles for the employer, more opportunities to trip over something, right? Because if you don't do it right, 90 days in advance, then your notice is deficient. And if your notice is deficient, you face the potential of liability under the WARN Act. So very important question, Sasha, and very important requirements there that employers need to be mindful of when they're trying to pull together a WARN notice.
And this is why most of them try to avoid being covered or try to claim one of the exceptions to having to give the notice, right? So
Correct.
Walk us through just at a high level, John, some of the exceptions that exist.
Yeah, I mean, the exceptions they're
limited and narrowly construed.
Yeah.
Favorite phrase of the lawyers.
Yeah. And then the lawyers will always tell you they're narrowly construed and you bear the burden as the employer, right? Because that's how it's structured. The big exceptions that we've litigated frequently under WARN are the unforeseeable business circumstance, okay, which effectively says, hey, if I go back in time 90 days ago, right, or 60 under the federal law to when notice would have been due, it was not commercially reasonable for me to foresee that I would need to close my business or engage in a mass layoff. And foreseeability is the standard that the statute, and the regs use. However, the case law is kind of teased out that, mere foreseeability, might not be enough. It needs to be kind of more of a likelihood, more likely than not. But that's an issue that's often litigated. We've litigated that issue here in New York with the Attorney General's office. There's plaintiffs will push you on that, but that appears to be the kind of the lay of the land on the case law, at least. And then there's a faltering company exception. And that says, if the company was seeking capital or business, actively seeking capital or business that would have been sufficient if obtained to, delay or avoid the need for the planned closing or mass layoff, and if issuing notice would have scared away your ability to obtain that capital or business, then you can be excused. Okay, those are kind of the two big ones. The other one that has always been in there is the natural disaster exception. I don't think I dealt with that exception at all prior to the COVID pandemic, right? And then the COVID pandemic came around and everyone was dusting off that exception to see if COVID was a quote unquote natural disaster, much like folks were looking at COVID to see if it excused performance under contracts as a force majeure event or an act of God. That's been an actively litigated thing. I think the case law on that is a bit all over the map, but what I've seen is largely been not in favor of the pandemic being a natural disaster, right? Go figure. So that's kind of left some employers high and dry. Outside of the exceptions, though, there are strategies, and I mean, I think this is what your question might have at least in part been driving at. There are strategies that employers seek to use to try to avoid having to give the notice when it doesn't make sense from a business or operational perspective. There can be concerns that employers or businesses may have that if I issue the notice, I'm not going to be able to continue to safely operate because too many people are going to leave, right? During that 90-day period. I'm not going to be able to wind this up in an orderly way. There's been concerns about increased workers' comp claims during that period, or sabotage or theft. There's all sorts of concerns that can get voiced during that period. And, depending on the particular business at issue, the industry and their circumstances, some of those concerns may be more justified than others. But in situations where the employer is trying to avoid giving warn, there are a few, and in situations, I should say, where you're not perhaps confident enough that one of those exceptions would apply. Some of the tools in the toolkit, if you will, are potentially staggering the employment losses so that you're staying under the applicable thresholds at all times. And this would probably be a good time to mention Warren's aggregation rules. I said in New York, we'll just keep it kind of simple. You're looking for 25 full-time employees to be impacted to kind of think that New York Warren could be implicated. What a staggering approach seeks to do is it seeks to stay under that threshold. But Warren does have a threshold, or a provision, I should say, that says, if you terminate one employee on day one and another on day two and day 3, 4, 5, 6, right? That's like too cute by half, right? That does not escape Warren, because what Warren says is it'll aggregate all employment losses generally that occur within 90 days of each other. Okay, so any 90-day period, you got to be measuring to see, have you hit that 25 threshold, right? So the staggering approach is trying to stay under 25 in every 90-day threshold. So, if you've got a facility that you want to shut down that has 40 people, say, right, 40 full-time people, you don't want to give the notice because you're concerned about, whatever issues it is that you're concerned about. You could potentially lay off 20 now, right? Stay under that threshold, wait, 94, 95 days so that you're outside the aggregation window, and then lay off the rest then. Okay. And if you do that appropriately, you should avoid having triggered the WARN Act notice obligations. So staggering is an approach. The drawbacks of that are obvious. It does string it out. And it's something you need to actively manage throughout that entire staggering period to make sure that you don't have inadvertent employment losses that cause you to, pop up over that 25 employment loss threshold, excuse me. And then another potential option is pay in lieu of notice. Interestingly enough, there's been some amendments to the New York WARN Act regulations on this that introduce some degree of ambiguity around the continued viability of this approach, but we think it's still good. The pay in lieu of notice obligation is an interesting one in New York, right? Because New York requires 90 days advance notice, right? 30 more than the federal law. However, the damages, if you fail to provide the 90 days advance notice, are only 60 days of pay and benefits. Okay. It's not 90 days, which is a little odd. But that's how the legislature wrote it. So if you don't want to provide notice, you just want to wind it up the way you want to wind it up, you can do that. If you're otherwise over the WARN thresholds, just pay the impacted employees the value of 60 days of their pay and benefits as a lump sum. And if you do that, you've effectively prepaid your WARN damages, and that is likely viewed, I should say, as compliance, even though you didn't give the notice. So those are some of the tools in the practitioner's toolbox, if you will.
So John, just to piggyback on a few things, I've been itching to get a word in. Thanks for reminding me what it's like to co-present with you. we've, we've done at least 100 speeches together, and this was a reminder. So to be clear, though, when talking about staggering the layoffs, that assumes that there's some discretion by the employer about when the people go. But to be clear, Warren can be implicated if the closure of the business or the layoffs or the termination of employment. Maybe it's not a layoff, right? The point is, it could be an involuntary closure, shutdown situation where the employees are being terminated, laid off, let go, not because the employer wants to let them go or close the business, but maybe there are socioeconomic issues that have forced it. And I'm thinking of a case that you and I had, without naming any client names, but when we were still working together, where the government came in basically and shut down a business. And that required significant layoffs that triggered the WARN Act. So just to be clear for our listeners, this could apply even though you as a business owner, you're ready to go. But, Uncle Sam or Governor Hochul is forcing the closure that will result in this number of employment separations. And then secondly, we've been talking about prepaying the damages. Can you talk a little bit about the damages? Because yes, there are damages that may be owed to the employees, but assuming you don't provide the notices, are there penalties? Are there interest, things that we have to talk about when we're talking about Department of Labor, wage and hour type of violations? Do those apply here as well? And do you avoid those if you prepay?
Yeah, no, great question, Amina. So the damages under the WARN Act, I kind of think of them in three buckets, if you will. The first bucket is the liability that you would owe to your employees, the impacted employees, and that is, at its maximum, it's 60 days of pay, and it's 60 days of the value of the benefits you provided them. It's both, right? It's kind of make whole, if you will, just very simply. You got to kind of pay them what you would have paid them had you given them 60 days notice. You got to kind of put them in the same position economically, right? And that is by far and away the biggest potential exposure. But it is very clear, right, as to what that is. It is a number. You could get it to a penny, and it's not a penny more or a penny less. That's the first bucket. The second is you are on the hook under the WARN Act for uninsured medical expenses that the employees incur during that 60-day period that would have been covered had you not violated WARN, i.e. they would have been covered by your insurance plan. And this is the one aspect of WARN damages that is potentially uncapped, right? So that if you shut down a facility with 100 people, right, you close the facility, you don't give any notice, everybody's sent packing on day one, no WARN notice, you owe all those people 60 days pay and benefits. But if one of those people, as they're walking across the street to go into their car, gets hit by a bus, right, and incurs several $100,000 of medical expenses during that period, WARN provides that the employer is effectively self-insuring that cost during that time. Okay, so that's something you need to take stock of when you're planning this type of pay in lieu of notice. When I'm doing that, I'm typically talking with my clients about, okay, to try to avoid this low risk but high potential cost eventuality, can we subsidize COBRA for 2 months, right? Can we continue the health insurance by working with our health insurance carriers? There's something we can do to try to take that risk off the table. That's the second bucket. The third and final bucket is the Commissioner of Labor has the ability to issue a $500 per day penalty for up to 60 days. So it's a $30,000 penalty that the Commissioner of Labor can issue for each impacted site of employment that is being closed down. So if you're closing down one facility, okay, and you don't give notice, the commissioner can come in and get her $30,000. If you're closing down two separate facilities, then she can get $30,000 for each. If you're sued, okay, WARN claims are the quintessential class action claim. If you're sued in court, I've yet to ever see an individual, Emina Poricanin, Sasha, on, just bringing their WARN claim and on behalf of themselves and no one else. It's always on behalf of everybody, right? It's the quintessential class claim. And WARN does contain an attorney's fee shifting provision so that if they prevail in whole or in part, as the employer, you're going to have the privilege of paying, your defense attorney, the Aminas and Johns of the world. And if the other side prevails in whole or in part, you're going to pay their attorney for the privilege of being sued.
Thank goodness that at least everyone who works with ForWork automatically gets arbitration agreements with class action waivers built in. I had to do a little plug, okay? Sue me.
Can you guys speak about the notices? I know that verbal notices don't meet the WARN Act requirements, right? So electronic, I would assume, but I shouldn't. So let me ask.
Yeah, I mean that's a really good point. And the world has really changed since these regulations were first written, 1988, 89 on the federal side, principally, I think, early 2000s, maybe early 2010s on the federal side, on the state side. I'm just not remembering off the top. But it has to be in writing. Okay, it has to be in writing. Verbal notice is not enough. The federal reports they contain cases of poor employers that only issued verbal notice and it wasn't sufficient, and they got hammered. And then the electronic notice is a really interesting one. The New York WARN Act regulations do permit emailed notices, okay, but they have a host of restrictions that go along with them that make the practicality of it not as good as you'd like. Stuff like the employees have to have free access to the email during work time at a computer on the work site, right? And that just that's not the reality of a lot of businesses, especially in the manufacturing or the service sector, folks that are in home care, right? They don't have the ability to look at a computer on site and access this email. So the ability to send it via email is, kind of, it just hasn't caught up with the real world. And then, I was asked recently about text message notice, and I can make an argument on behalf of it. The regs say you can provide it via any means that's reasonably capable of ensuring delivery, I think is in essence the test, but it doesn't contemplate text-based notice. And, if you're thinking about text-based notice and the New York regs kind of have all these hoops on email-based notice, query whether you'd have to try to comply with those obligations for text. So, the best way of doing it, Sasha, at this point still remains a hard copy notice that's hand delivered or overnighted or placed in the mail. That's typically the best approach to doing it, because the email gets a little tricky.
Any last questions for our esteemed guest?
Yes, actually, when a business is sold, even an asset sale, WARN applies, which was surprising for me reading that, right? So does the risk go with the buyer, remain with the company, even if it's an asset sale? And I don't recall ever seeing a WARN Act provision in sales that I've been involved, or sale conversations I've been involved in. So can you speak to that a bit?
Yeah, that's a really good question, guys.
It is, and I will tell you, I did not feed Sasha this question. Sasha actually comes up with all of the questions. Surprisingly, I do get people texting me, like, do you tell Sasha what to ask? It's like, no, Sasha is smart. Sasha,
yes, and to be clear, I have not got these questions in advance either. So,
oh yes.
Yeah, this is all contemporaneous. This is live, right? No, I all kidding aside, that's a really good question, Sasha, and it's actually got, it's kind of part of the history of the Federal WARN Act. The Federal WARN Act initially in Congress was proposed without a provision that addressed sale of business. And some of the Republicans in Congress at the time, as this bill was making its way through Congress, they flagged this issue. Like, hey, is this law going to require 60 days advance notice to employees every time a business is sold, even though the employees aren't losing their jobs? Right. And then that led to what we now have is the sale of business exception in the WARN Act. Okay. And the sale of business exception is kind of best understood, I would say, as applying to asset sales. Okay. I.e., the types of sales that you would need this for. Because in a stock sale, the employee is, coming to work for Acme Inc. The day before the sale, and they're still working for Acme Inc. the day after the sale. It's only the ownership, right, of Acme Inc. that's changed. So from the employee's perspective, there's no employment loss. There's no arguable employment loss. It's all status quo. In an asset deal, it's different, right? In an asset deal and in some merger deals, really, it's different. You're going from Acme Inc., right, to, Poricanin LLC, right? And when you leave Acme Inc., you're technically having your employment terminated. And you're starting a new employment with Poricanin LLC. And it may be that that's instantaneous. As of the day the deal closes, you are terminated by Acme Inc., and your employment with Poricanin LLC immediately starts, right? So that there's no real loss of employment. And that's what the sale of business exception was designed to address and specifically permit. And it's got two components to it. The first is it divides between the buyer and seller the responsibility for issuing WARN Act notices where required. Prior to the sale, it's the seller. After the sale, it's the buyer. Okay, so it divides the world into two. All right, that's the first component of it. The second component of it is called the deemed employee provision. And effectively it says is that all employees of the seller as of the date of the closing are deemed to be employees of the buyer for purposes of WARN Act only. So WARN Act effectively takes them from the seller, zaps them over to the buyer, it deems them to be employed, right? And then if enough of them are not rehired by the buyer, or if none of them are rehired by the buyer, it's going to be the buyer's problem. Okay, it's going to be the buyer's problem, and that's a nod to the reality in most of these situations that of between the seller and the buyer, the party that's making the decision on which employees are staying, it's typically the buyer, right? So that's what this does. It kind of takes the employment from seller to buyer so that there's no technical employment loss there when the seller terminates you, right? It just deems them to be employees of the buyer. And then it's really on the buyer to make sure that they are employing enough of these folks, offering employment to enough of these folks so that you don't trigger WARN. In situations, Sasha, like you were saying, where you've been involved, when the employees in an asset deal, when all of the employees are going from seller to buyer, there's no gap in employment, right? That's exactly what this provision is designed to do, is to really take WARN out of the equation. Where you can have WARN show up in these situations, even with the exception, is, the buyer's taking the business, but they don't want the employees, or they don't want all of the employees. And the people that are going to be let go, there's enough of them to get to those triggering thresholds we talked about earlier, i.e. 25 or 50, kind of at the most general level.
Well, thank you so much, John, for taking the time. This was a great conversation. Things that I would not have considered just normally. We're a sizable business, especially you're stating that New York has a lower threshold. A lot more people qualify for this that may not have considered it. So, thank you. I'm sure a lot of our listeners appreciate the education, and I'm sure we'll see each other soon. But thank you for taking the time.
Yes, we'll bring him back again, whether he wants to or not.
Yeah, for sure.
Absolutely, guys. It was my pleasure. So nice seeing both of you.
Thank you.
Right,
Thank you.
thanks.
Bye.
All right. Again, we want to thank John Godwin for joining us. Thank you, listeners, for tuning in here on YouTube. So we are trying to get people who've been listening to us for years who haven't had access on Patreon. Please consider following us, subscribe to the page, the Home Care Forum podcast. I will continue to posts on LinkedIn. So follow me, Emina there. I tag her. You can follow the page, the Home Care Forum podcast. Let's get our followers up. Please share. Continue to share. We've had some people sharing. I'm impressed, and I like the numbers. Emina wants more, so let's do it for Emina. Let's make her happy with the followers, the likes, and all. So
Thanks, everybody. The more you follow us, the more we can actually provide this for free without the paywall, which is something that I know everybody's interested in, because the YouTube account is not behind a paywall, and so your followership ensures that we can keep it up there for broader viewing and information in the home care industry.
Great. This has been the Home Care Forum podcast with your hosts, Sasha Guillaume and Emina Poricanin. Have a good one.
Thank you.
Thanks.